Hi everyone, this is Dr. Vishal Sharma of Metanoia Inc. And in this little video, I'm actually going to talk about 4 developments in the intellectual property world that are going to impact the IP activities in high technology areas. The IP activities of copywriting, licensing, trademark, patenting. This is actually summarized from a very nice IEEE ComSoc panel that happened just a week and a half ago. And due acknowledgements to all of the great speakers there, Jeffrey Miller, Alicia Shah, Gwen Murray, and my colleague, Dr. MP Divakar. And you'll find links to that presentation and all of the details of that in the mind map that I'm going to include behind this video. But in this video, my goal is to give you a little bit about my impressions and my distillations and a quick synopsis of what went on. So there are 3 things that we're going to talk about. What are the changes that have been brought about in the patent community as a result of the America Invents Act? Second, we're going to talk about Alice versus CLS Bank and what that has meant about what is patentable. And third, we're going to talk about the open source licensing provisions and what that means for the whole slew of startups and companies, both big and small, that are beginning to use open source very extensively in their products and services. And finally, we're going to set all of this in the context of the Internet of Things, or so-called IoT. Now, as many of you might already be aware, the Internet of Things is a huge juggernaut, a phenomenon that's being talked about in the industry, and some have argued that it's a lot of hype. But as we'll discuss later on in this video, you'll see that there are some reasons why an amalgamation of circumstances have come together to make this happen today, and why that's going to be significant going forward. And so I wanted to let you know that the purpose of doing this is, of course, to share my insights and my learnings with the community, and also because we at Metanoia Inc., we work in intellectual asset management. Among other things, we help companies with strategic insights into their patent portfolios, into looking at new technologies, into deciding what to license and what to keep away. And we work with members of the legal community. So my hope is that the members of my friends from the legal community will learn something about a synopsis of these legal developments, because sometimes very difficult to track all of them by oneself. And my friends from the technology world and the communications world will have an appreciation at the end of this video about what the legal framework means for how they're going to build their companies, how they're going to monetize their inventions, how they're going to patent their inventions, and finally, what part is patentable. And if you use open source, for example, what are the provisions that you need to be careful about to both honor the requirements of the open source community, while at the same time deriving tremendous value from any enhancements that you make. So let's dive right in. And I have a bunch of notes here, so you're going to find me reading off of them, because I wanted to make sure that I got everything right for everyone that's going to watch the video. So the first thing we really want to look at is, let's start with the context of the Internet of Things. And what is the Internet of Things? So fundamentally, it's about connecting devices. It could be end-user devices, or more importantly, industrial equipment, over the network, and enable gathering of information from these devices, so instrumentation, and the management of these devices through the network. And this information is, all of this is done over software, and the purpose is to increase efficiency and enable a whole slew of new services that will either improve health, wellness, safety, or the environment. And we'll see applications in all these various domains. So that fundamentally is what the Internet of Things is all about. The question, of course, is that even as whether we are members of the legal community or technologists, we really want to understand why has this come about today? What is so special about things today? And there are 2 key developments that impact that. One is that the cost of connectivity has gone down tremendously in the last decade, and the other is the cost of processing has gone down. And just to give you a sense, sensor technology is at a point where sensors are down 54% in cost in just the last 10 years. Bandwidth, something we need to interconnect these devices and the network and the cloud computing servers that are sitting at the back end, is down 40x in just the last 10 years. And then if you look at processing power, which you need for computation, that's down 60-fold in the last 10 years. So as you can see, this is a perfect storm in a positive way of technologies that are coming together to make things happen. And then the other enabling factors are, one, the ubiquitousness of our smartphones, which have essentially become the gateway to IoT, because we can communicate not among ourselves, but also with all kinds of machines and devices using our smartphone as the interface. And the other is the ubiquitous availability of Wi-Fi, because connectivity is through Wi-Fi. And these 2 factors allow the communication between the people, the processes, and the end devices to happen. And The impact of processing power is that we can now swallow, churn, analyze huge amounts of unstructured data, which is basically what these sensors are producing as, or these machine-to-machine communications are producing. And we can make sense of that data to create sort of analytical insights that can be then used to manage ourselves better, manage the society better, manage processes better in an industrial environment, and so forth. So just to give you a sense of this, there's a beautiful infographic that was produced by Harbor Research and Postscapes that I would love to share with you, and I'm going to do that through a screen share here, because it makes so glaringly obvious, some of the things that are going on. So let me, in fact, do that. Oh, that was the I wanted the web example and not the actual presentation. So let me start right at the top. What exactly is the Internet of Things? So I've already given you a sense of that. What we want to add to that is that really it's more about than just about connecting devices. You're basically building smart connected systems that are going to create an economic phenomenon, presumably of unprecedented scale, and that's going to encompass billions of interconnected nodes, which are these endpoints. And really, there are three components of this IoT phenomenon. One are the sensors and actuators that actually are the endpoints that are collecting the information that we use. The other is the network connectivity, which gets that information to the end product, either people or processes or computation engines that are going to crunch that information. Finally, you have the people and processes that are going to act on that crunched and analyzed information to actually affect something, a change. So the sensors, just to give you a sense of this, is the wide variety of sensors that are actually available today. And let me do a full screen here. So here goes. I mean, you can do sensing of position, motion, temperature, velocity, humidity, acoustic signals, vibrations, chemical and gas, flows, electromagnetic radiation, all kinds of force and torque, even optical signals. And you can take all of these sensor information, which is actually building a digital world around us, and building a digital nervous system for the mechanical world around us. And you connect these, you first digitize these inputs, and then you connect them through the network. That's where all the networks from Wi-Fi to LTE to 4G and 5G and all of the big core wireline optical networks come in. You connect connect these digitized inputs over the network to some computation engine where it's being processed and analyzed, and then you have an interplay between these processes and people. So there's a one-way flow of information from these devices to the processes, an analysis of this information, which leads to some kind of decision-making capability where people then effect those changes back again in the network to create something useful for society. And the best example that I want to give you is later on in this very infographic. But before that, let's talk a little bit about the wide variety of applications of IoT. We've already heard about smart thermostats, connected cars, activity trackers like our Fitbits, smart outlets that can turn off your devices or turn off the outlet when you're not using them, and smart parking sensors. And talking of parking sensors, here's a very neat example of how you can combine transportation and smart cities to produce something of value. So think about this example that's illustrated here. Sophia and her son are going to the market. So they drive around in their smart car, which is talking to the special parking meters in the city, and is able to determine by communication what parking spots are vacant. So you land up there, save a lot of time, not kind of roaming around as we do in San Francisco today, for example. A majority of the traffic, as an aside in San Francisco, is due to people looking for parking. So you can save a lot of time and a lot of traffic. You park, and then while you're away, your car communicates over the network, letting sort of a mechanic know that it's in need of an oil change. And a mobile mechanic comes by while you're out shopping for a couple of hours, does the oil change, you make the payment using your smartphone. The mechanic receives their payment using some kind of a smart device. Everything is done digitized and electronically with these devices talking to each other. But of course, the human being is taking an action as well of making decisions based on the information, just as I described earlier, and you're done. So that is the power of the Internet of Things. Now, just to give you a sense of the size of the market, in 2014, the market is slated to be $180 billion. But if you look at the same thing going just about 6 years later, which is really a blink of an eye, the revenues are slated to be over $1 trillion. But the interesting point is that even though we as users tend to think about our smart, phones and our homes, and talking to, our fridges and our, intelligent microwaves and such, really most of the IoT devices are going to end up in factories, in businesses, or in healthcare. In fact, another study showed that by 2025, the global worth of the IoT technology, which is going to be about $6.2 billion, is going to derive from two main sources. One is use of IoT in healthcare, which is going to be $2.5 trillion, I'm sorry, and use of IoT in manufacturing, which is $2.3 trillion. So of the 6.2 trillion, almost 5.8 trillion, a very large percentage, 80% or more, is going to come from sort of industrial internet and IoT and healthcare. So that kind of gives you a sense of what's coming down the pipe for IoT. Now let's dive right in and start talking about what does this mean for how does that get impacted with the recent legal developments that have been happening in the legal world. And the reason this is important is that we as technologists need to understand the legal framework in the context of which all of our companies, innovations, ideas, software, and hardware actually operate. And it's becoming more important today than ever before in the past, because as you'll see, we're talking about interoperable components, we're talking about free use of open source software, which kind of changes the game. So let me start by talking first about what has been the changes in the patent law with the coming of the America Invents Act. So the Invents Act came back in March 2013. So we have less than 2 years of case law on it, but there are few things that changed with it. So two major things that changed is we went from a first to invent regime to a first to file regime. And the end effect of that was that effectively the grace period that you have for the filing of your patents is effectively gone. And the second change that came about in the regime is this post-grant review process, which allows you to challenge patents post facto and makes that mechanism for challenging patents a lot easier than it has been in the past. So what this entails is that you now have to, the way this impacts intellectual property strategy is that startups, companies in the high technology area, whether it's communications, cloud computing, telecom, or IoT, have to think about their inventions and have to think about their patents in a completely different way. So let's talk about what the post-grant review process is and how that changes things. So the post-grant review process is actually a series of procedures that are possible, the most important of which is what's called the inter partes review, abbreviated the IPR. And essentially, anyone can file an IPR against an issued patent. The only requirement is that the only things you can challenge, only grounds on which you can raise a challenge is anticipation and obviousness. So this has been, so the key result of this is that issued patents now are more susceptible to validity attacks, and they may not give us the exclusivity that we desire. And of course, it can be used as a harassment tool or a business disruption tool if somebody just tries to file an IPR to create nuisance value. On the flip side, the advantage is that it provides a very cost-effective way to defend against infringement claims, especially for smaller companies, because if you have a very strong invalidity defense, you can file an IPR process where the barrier to proof, the burden of proof, is lower than the clear and convincing evidentiary evidence that is required in a sort of district court. So that makes it easier from a startup's perspective to defend against infringement claims. On the flip side, however, it also makes it easy for larger companies and other entities to potentially sue a startup that has patents in that space. So you have to be cognizant of that. And as I said earlier, the elimination of the grace period basically means that new companies have to think about intellectual property and patents a lot sooner than they traditionally do in the business development cycle. And that's an important caveat for founders, senior architects, investors that have to worry about it. And also for our friends from the legal community, because that changes the kind of advice we would give to startups about when they should start the patent process. And there's a good reason now for starting that early and making that investment upfront. The second way it changes is that, as I said earlier, is that with the IPR process, your patents are susceptible to invalidity, so you have to be cognizant of that. And at the same time, it makes it a little bit easier for small companies to fight cases of infringement by filing an IPR process. Now, how does that, in fact, what does this mean for infringement? Well, it has 3 or 4 implications for infringement. The first is that in the Internet of Things world, and in sort of telecom and networking, generally speaking today, there's a lot of interoperability and interaction between a wide variety of components. So one has to be very careful in the way in which we draft claims, because the claims have to be drafted from the perspective of the device that is really our innovation and how it communicates with the other devices. And the reason for this is the following, that if you have claims that talk about the interaction of various devices and are not carefully drafted, then potentially it's very difficult to show that the entity that's liable for infringement is a single actor that's performing all of the acts that are required to violate a claim, because now you have multiple components that the claim involves, and they may all not be owned by the same entity. So therefore, what that means is the claim drafting process has to be very carefully done. Both the engineering talent in the company and, of course, the legal community have to be cognizant of that, and especially cognizant of that. The second is that the provisional patents, when you draft them, you have to be significantly more careful, because they may not give you the protection that you desire. And the reason is that if you thought that items A, B, and C are critical, and that's what the provisional patent is on, but by the time the 1-year deadline came along, item D has now become important, and that's become part of your invention and wasn't thought about earlier, then essentially the provisional patent gives you no protection. And that's something very, that impacts, how you can file a patent and how you should craft a patent. Now let's move on to the second part of our discussion, which is the Alice versus CLS Bank issue, and what that judgment from the Supreme Court, which came, middle last year, actually means. So basically, what the Supreme Court has done is periodically it keeps, through various judgments, reiterating to the patenting community, and of course all of us are inventors in technology, what really is patentable. So first and foremost, laws of nature, natural phenomenon, and abstract ideas are not considered patentable. And within the class of abstract ideas are included fundamental economic practices, methods of organizing human activity, and other ideas. So what does that really mean in the IoT community? Now, as we know, IoT is all about devices talking to each other over networks. And in many cases, right now, we are still at a stage where we are figuring out where the various innovations and enhancements are. There are some fundamental big ideas like devices talking to each other, but under the Alice versus CLS Bank, these may not be patentable. So again, we got to be cognizant of that. And what that means is that the claims should not cover patent ineligible concepts. And secondly, there should be, in the way we draft our patents, some kind of an inventive concept. And how do we define that? An inventive concept is basically a combination of elements that together is sufficient to ensure that the patent in practice amounts to just more than a patent that was based on the abstract ideas would amount to. So that means you have to again think about claims and your actual inventions very carefully. So basically, this means you cannot just recite a business practice and say, now it's happening over the internet, it's happening over a network, and that's good enough to be patentable. It may still be a fundamental idea, but under the SCOTUS, the Supreme Court of the US, under Alice, essentially is giving guidance that that's not something that would be acceptable. So then what we need to do in the IoT world and advanced technology in general is to think about implementations and infrastructure. And they have become a lot more critical now. So for example, in the IoT case, you can think about sensing technologies, power saving technologies, chip design innovations, communication protocols, telecommunication standards, transmission methods, computational advancements. These are the areas in which we can hope to innovate and really get patents that are sort of meaty and talk about specific implementations. And that's where a lot of the innovation is likely to be. On the flip side, we can also come up with solutions to problems that are introduced by the technology itself. So here's what I mean by that. Say you're in the IoT world, your cell phone is now talking to devices, your car and devices in your home. And so you want this communication to be encrypted. You don't really want the rest of the world to see what is happening, which basically means that now security, encryption technologies, and security algorithms are something that have been introduced as a result of our use of this IoT technology. And they are a great place to think about patenting new technologies and new inventions. So the other big change is that if we actually do have a big idea and it's not yet reduced to a specific implementation, we don't have a good idea about that, it's probably something we can protect under a trademark situation. And we should trademark it until we are ready to have an implementation that has innovations that we want to innovate and patent on. And by the same token, there are ideas where you might want to create copyrights, which you wouldn't normally have thought about. So trademarks and copyrights, which small startups and smaller companies typically don't think about, are things that are alternatives in the IoT world that are worth thinking about in the current environment after Alice. And then the third thing that I wanted to talk about is open source licensing provisions and what they mean in the IoT world. So as we know, generally speaking in the industry, there's a huge push by both big and small companies to use open source software. Why? Because it's done by the community. It's got the brain power of the community beyond in it. It's typically in many different areas of technology, open source software is extremely robust, extremely well done, has applications, is extensible, and so on and so forth. But the key here is that open source software is not necessarily all free. There are different kinds of licensing models for open source software, and any innovative company that is using it, big or small, needs to be cognizant of what the implications of their license are for what it can claim as its own innovations, what it can patent, what it's supposed to disclose to the rest of the world, how much of its own software should then become open source depending on what it inherits, what's grandfathered in from the licenses that have been used and so forth. So let's talk about the three key licensing modes here. One is called the permission-based or attribution-based license, which is essentially a license which says, look, you can do whatever you want with our software, just so long as you give us attribution that we are the source of it, and under very minimal sort of attribution requirements. BSD, a Berkeley Standard Distribution License, under which Unix is BSD Unix is licensed, is an example of that. The other extreme is what's called strong copyleft, and copyleft is nothing to do with copyright. It's just a terminology that has come up, where the fundamental precept is that the source code must be made available to the end user. So if you use something that is already licensed under a strong copyleft license, an example of which is the GNU GPL license, if you use something under that in your own product, then you could be obligated to license and make available your own source code and software. So you have to be really careful at which point to draw this boundary when you're using strong copyleft software under those licenses. And of course, as you might imagine, there's a middle ground which is file-based copyleft. And what that really means is it has a much clearer direction on what you can do with any modules or applications that you yourself, as a user of that software, open source software, creates. An example of that is Mozilla's public license. So what does that mean for companies in high technology? Well, it basically means that if you create a derivative work using this software, open source software of any kind, and you then start distributing it, you have to think real long and hard about what exactly is a derivative work and what does distribution mean. And that's where we don't have enough case law today. So a derivative work is something that's not really well defined in this context. For example, people are still arguing over, okay, I take some open source code, I link it statically within my code and then distribute it. Now I'm obligated to distribute it under the same conditions as the open source license. If, however, I link the code dynamically at runtime, then it's a different model. I'm kind of using that module, but my code could be considered independent of the open source code. And so my licensing requirements are a lot less stringent. So these are things that are being worked out. There's not enough case law for that. Similarly, on the distribution side, there are a lot of open questions today. For example, if you use contractors, what is that a distribution? If you use affiliate companies to which your software is distributed, is that a distribution? And more importantly, if you use software as a service, which, by the way, according to some definitions of GPL3 licenses, is considered a distribution, then you have a potential problem, because if you're a software as a service provider or a software as a service company, and you're using GPL3 licensed open source software in your software, then potentially you become liable because of the requirements of the license to actually license and make available your source code to the end consumer. Now, that's clearly something a small startup with innovative products and services might not want. So what's the way around that? The basic way is that the companies have to think really hard about where they're using open source software, how much of it they're using, where they can draw a box around it, and what the stuff outside of it is that then they can potentially patent, and what their obligations are to the open source community. Because the open source community at the end of the day is made up of extremely proud and extremely good software programmers who like more than anything else to generate good code, but they like to be acknowledged for it. So you really don't want to make an error on that count. You want to acknowledge the code appropriately, meet the licensing obligations, and at the same time, retain your own innovations to do something. And so both the legal community and so that the technology folks have a critical role to play here in terms of dialoguing early on what the implications are of using open source software. And the reason this is important is that actually, a lot of investors, joint venture partners, VC companies, potential partners, acquiring companies are today become cognizant of the fact that there is a lot of open source software in products and services, and they want to know how you're using it and to what extent you adhere to the various licensing requirements. And I know, Jeffrey Miller in the panel mentioned that he's seen examples of deals that have simply fallen through just because people couldn't work out the details of how open source was being used. So it can be that important, acquisitions, it can change the value of the company. There's a lot of implications to how that can actually impact you. And therefore, I believe it's really important for us as a community to think about it creatively. And now, in closing, let me give you a few highlights of what came about from the Q&A that we actually had at the end of the panel. And some of them I've already given you, that provisional patents can give you a false sense of security, that somebody can beat you to the game since it's a first to file regime now. You need to be really careful when drafting claims to be sure that it's the entity in question that the claims are drafted around, and that's the frame of reference. But at the same time, you have to be careful that you retain the usefulness of the invention and the system or the software that you're trying to patent. And one of the questions that was very interesting was, guys, open source has been around 20 years. We haven't seen a whole lot of litigation in there. What's the worry? I mean, why are we talking about essentially a non-problem right now? And I think I like Gwen's response to that. And she mentioned that, look, one is that there's a lot of use of open source in the last 4 or 5 years than there's ever been before. The second is there's a lot of consciousness of the use of open source and the fact that you need to honor licenses. And third is, most importantly, the business community, investors, joint venture partners, acquirers, and such, and the legal community are looking long and hard at how companies are using open source and whether they're doing the right thing. Now, the other interesting part that came up is that apparently there are detection softwares that you can take 1 million lines of code, run it through a piece of software, and it will tell you to what extent and where you're using open source. The only two problems with that is, number one, that can be expensive, anywhere from $250,000 to $500,000 to run this through multiple such programs, because you want redundancy and reliability. And the second problem is that they give a lot of false positives, a lot of errors that you then have to sit and mine through to determine where exactly you're violating various open source standards. So the solution really is not to do things post facto, but rather become conscious of it through this process of education that we're trying to do here, and many, many other forums as well, and understand the implications and start working on compliance early on in the process. So that's the goal. The technology community, the technical experts, the architects, the network engineers, the executive management and engineering management kind of need to be made aware of how thinking about this early on is a big win. It's a great investment of time. And by the same token, the legal community, I think, perhaps has to also advise the technical community about the value of doing this early on. So that, in a nutshell, is a summary of this panel and what I learned from it. I hope you've enjoyed it. I hope you've learned a lot in terms of the takeaways. If you have any questions, you're welcome to contact me at the address shown below and in the description of the video. And if you are working in the intellectual property area, then of course, as I said earlier, we're very active in this area. This is an area of practice for us. We'd love to work with you, interact, and find out more about the kinds of problems you're solving. And we love working on hard problems. So once again, as we always say at Metanoia, keep those little gray cells working. Do your critical systems thinking, and make sure that we are powering innovation, leadership through innovation. And I'll see you next time. Thank you very much.